Hello and good evening. Welcome to the latest Hey Legal social live stream. We are live tonight on YouTube. And hello to all of you who are watching on catch up. At Hey Legal, we are always looking to cover the most relevant topics of the day, and that is especially the case with the social. Tonight, that is especially so. And it's impossible to look at news websites at the moment without seeing headlines about the proposed reforms in the Scottish criminal legal system, or the impact indeed of technology and in particular artificial intelligence. So tonight we are covering all of these areas. Thanks as ever to our sponsors, De Novo, The Cash Room, Law Scott, CPD, Patterson Financial Planning and Bundle Docs. So we start tonight with a very special guest, none other than Donald Findlay, KC. Good evening, Donald.
Good evening.
How are you?
Yes, survived another day, so
Good stuff. Well, Donald, really, where to start? I don't imagine, or I can't imagine that you ever thought you would be living, working still amongst the proposals that we are seeing coming out of the Scottish Parliament at the moment. And we know that lawyers have been very vocal, have unanimously almost condemned these proposals. But I suppose some members of the public might be thinking that we are opposing these on the basis of self-interest. I wonder if you might start, Donald, just by explaining why citizens and the general public should be concerned about what it is the Scottish Government are proposing to change within the criminal justice system.
Yeah, I think it's important to understand that one of the most important freedoms that we enjoy in a civilized society is liberty. And your liberty should only be taken from you by the state after due process of law, and where either you are remanded to await a trial, and there needs to be good reasons why you should be kept locked up to await a trial, or you have been convicted by a court. Now, for many, many years, it has been thought right that the liberty of the individual should only be taken away where that court consists of a judge to deal with the law and a jury to decide upon the facts, to assess the evidence. Why is that important? Because it's democracy. And a jury is arguably the only real existing true bastion of democracy. Because 15 people are chosen at random, no special qualifications, and they bring together a huge experience of life collectively. And they bring that to bear on the question of whether or not the guilt of an individual is proved. Now, if you say that is not the best system, then there are arguments to be had. But if you say that one individual is better than 15 jurors, then you are striking at democracy, because you are implying that somehow an individual who is a qualified lawyer is better equipped to judge on the guilt or otherwise of the citizens. So what that means is members of the public are not up to it. They're not bright enough, they don't have enough experience, they don't have enough common sense to serve on a jury and determine these things. And if that's right, that is a direct attack on democracy, because the same principle could be applied then if you go back to Brexit. You should only have been allowed to vote if you understood what the issues are and could pass a test of 20 questions and get about 14 or 15 right. And in Scotland, if there is an independence referendum, then you shouldn't be allowed, if you're going to vote on an emotional basis, you should only be allowed to vote if you're going to do so on a logical and rational basis. So to try and take away the jury in any situation is actually an attack on democracy and the liberty of every single individual in this country. It is as fundamental as that.
Yeah, absolutely. And you and I know that judges from either the appeal court or even at the end of current jury trials will thank a jury for what they bring to the process. They'll tell the jury that without them and their collective life experience, we wouldn't have this excellent system. So it does seem to be a real slap in the face to say to juries, you're just not equipped to deal with, well, obviously sexual cases is the proposal here, yet they're to be trusted in other areas. What logic can you see for that, Donald?
Well, I can see a very clear logic for that, of course, because if you come to the view that juries cannot be trusted to deal with rape cases because of preconceptions, and nobody has as yet told me what these preconceptions are, call it bias, because that's the allegation that's been made. Then if they're biased, then you should define bias. And nobody's done that. But if you say that they are not bright enough or don't have enough experience to try a rape case, but they do to try a murder, or maybe they don't. So the logic is, if they can't try a rape case, they can't try a murder, an attempted murder, a complicated fraud, a fairly straightforward assault. So in effect, what you are doing is striking at the very heart of the jury system, and you are saying the people of Scotland are not bright enough, clever enough, or worldly wise enough to be involved in the trial of their fellow citizens as they have been for hundreds of years. That is the most unbelievably insulting change that any Scottish government has ever suggested should come about in the legal system. And I am disappointed and appalled at politicians of all colours who have joined the queue to support this particular proposal.
It all becomes so convoluted because, as you say, these questions haven't been answered. We haven't been told really what the base is, other than it has been said outright that conviction rates are too low.
What does that mean? I don't know. You tell me what that means. What does it mean? Conviction rates are too low.
I'm none the wiser either, Donald. I've been asking the same question. That was my next question for you, though. What do conviction rates? What do they tell us, if anything?
Well, I suppose conviction rates, they take us in the world of statistics, in which case you can use statistics to prove anything that you want. So the conviction rates are too low. That means the Crown cases are not good enough to succeed. So why don't they make the cases better? Why don't they make the cases stronger? Why don't they put more resources into it? Why try and circumvent it by changing the whole system? It's also deeply worrying because this is a concept you'll struggle with, Edith. If I was a judge, I know you're not going to be able to work that one out, I would be mortally offended at the suggestion that somehow I'm going to be fundamentally more inclined to convict in a rape case than a jury. That's implying I'm prejudiced. And I would take the very gravest exception to the suggestion that simply because a rape case is presented to me, I would be more inclined to convict in that than any other case or a jury would. That strikes at the independence of the judiciary. And I know the judiciary are not allowed to speak about matters publicly, but we are. And I would be deeply concerned about the independence of the judiciary under this proposal, especially when the senior judge is going to be able to remove judges who don't convict enough, whatever that may mean. So is the Sun going to publish a table of conviction rates? And if you acquit 3 in a row, that's it, you're out. 3 strikes and you're out. I mean, people really must understand this is striking at the very heart of the justice system. For what reason, I know not.
No, absolutely. And again, it's not clear what the pilot that's proposed, what it will be measured against. Will it be measured against conviction rates? Will it be measured against, which judges are performing correctly, whatever that test is. It all seems a kind of bumbling through, and there are probably more questions raised than answers given.
I don't think lawyers understand what is meant by the conviction rates not high enough. And there is no research to back this up. And I've heard talk about the research, but the research, or what is being described as research, was some university project that was no doubt good fun for the students, but it didn't even bear a passing resemblance to actual trials. So that's not research. So there's no research. The language of it is actually meaningless. And words should have a meaning. And conviction rate has no meaning to me whatsoever.
Yeah.
And yet that is the basis for this fundamental change.
Absolutely. And I think, as you say, it's what is it being compared with? Where are the comparators? Because in other, if you point to other legal systems, then their test for putting a case into court's different than here. It seems, and we see it ourselves, that perhaps the requirements before a case is prosecuted here are lower than elsewhere. So maybe there's other, the cases there are more cases, or the quality is lower. It's just it's comparing apples with oranges, and it's not clear where these things are coming from. But it seems that the people defending this are speaking with such conviction, and that's the concern, isn't it? Because the MSPs who will be asked to decide upon it, I guess it's difficult to stand up against it unless they too are educated and understand what it is that we're saying about it. And we're not speaking from a position of self-interest, because I dare say we could whiz through lots of cases, or we could find a way to get through it. We're standing up because it's not right, and it's not just, and it's not a transparent system, and it's been done for all the wrong reasons.
Hang on, Edith. You're saying the MSPs will decide. The MSPs can't decide, because they're not qualified to decide. Because if jurors aren't up to the task of sitting in a rape case because they've got preconceived notions, or they don't know enough, or they don't understand enough, where is the evidence that the MSPs understand this or are qualified to really come in to see how the legal system works? And the answer, of course, is they don't.
Yeah.
You and I know that if you go and talk to people in all walks of life, one of the first things they ask us is, what do you actually do for a living? Because they don't understand how the legal system works. And I have not the slightest doubt. And I'll throw out the challenge to any MSP, a group of MSPs. Sit down and discuss how the legal system works, and let's see just how much you actually understand about this, rather than what is being spoon-fed to you by your party managers.
Absolutely.
That'll make me even more popular with MSP.
But you're right, because you could apply the criticism that's being levied at juries in rape trials could be applied to every aspect of society in any important decision making. And it doesn't follow through. I suppose we've got Neil Hay who's going to come on shortly, but before we get Neil in, and we lawyers are criticised as well. We've been criticised, it seems, by Nicola Sturgeon for just complaining about things before anything's even decided, to dare to have a voice about it. But it is one thing about saying what's wrong with it, and that's all valid. But what do we do about it? What are your thoughts on how we address it, Donald?
Well, I have every sympathy for my colleagues up and down the land who have come out and said clearly they will not take part in the proposed trials, or whatever it is to be called, the test cases. For my own part, at this point in time, I want to wait and see what I'm not going to do, because it's not clear to me exactly what this trial is going to involve, and I think we should really wait, because there's a lot of water to flow under the bridge before these things ever take place. There's all sorts of things may or may not change, and I would personally want to wait and see exactly what the proposals are before I have to come to any obvious conclusion about the part I may or may not play. However, In the meantime, this is what we lawyers need to be doing. We need to be talking about it, not just talking to each other, but talking to the public, talking to the politicians, and getting over to our side of the argument. And frankly, if the former First Minister, Nicola Sturgeon, is getting all hot and bothered about it, then we're already making a good start in terms of the argument. Because, of course, under a Sturgeon government, it was her way or it was the highway, and you weren't allowed to discuss it, and you weren't allowed to debate it, and you only had to sit there and do what we're told. Well, that seems to have changed, at least, because we don't have to listen to her anymore. But we do need to talk to the politicians and make the case calmly and rationally, because it is as fundamental as a strike at democracy itself, and it's our duty to resist that.
Yeah, and we're the ones that have the knowledge, and you know, we've seen the photos of complainers meeting with government ministers, etc. And of course, they should have a voice, but it should be balanced, and you know, we should be involved in the conversation. Just before, we're just going to bring Neil in shortly, Donald, but just before we do that, I just wanted to play a little video, and it's your good self, because you'd recorded some material for the Shaping Your Success CPD channel, and it was just something you said that I thought was very pointed and relevant for this discussion. So I'm hoping Ali's got that teed up and we can maybe just play it just now.
You should never be told what to do and accept it without question. When you go into the legal profession, you've got to be prepared to stand up to anything and everyone that comes your way. And the way that you enable yourself to do that is you do your homework. You understand your case. You identify the problems involved. You know the other side's arguments better even than you know your own. You understand what is coming your way. So that whenever a point is made to you, you can say, yeah, I know that, but that's not right. The answer is. So much of it is preparation. You then have confidence in yourself and what you do. Because if you have done your research, if you have prepared the case, there's no reason to fear what's about to happen. Always remember, go into a law library and look at the row upon row upon row of session cases, Scots Law Times or whatever. In 95% of these cases, there were two sides who thought they were right. But only one of them was. So you won't win all the time. And never, ever be bullied. Not by a colleague, not by a judge, not by a prosecutor, not by the other side, not by your boss. Never let anybody push you around. Never let anybody tell you what to do. And if you want 3 fundamental principles to guide you, never explain, never complain, and never apologize.
So obviously that was you talking about preparation for a trial process, Donald, but there are relevant comments there that, you know, we apply here too, in particular, just being, well, we have the knowledge, we are prepared, but it's just conveying that and being confident and standing up to this, as you say, attack at the heart of our criminal justice system.
And if I was saying that now, I would add, and absolutely, don't do what politicians tell you to do. Do what you think is right, because there is absolutely no guarantee that they are right. In fact, time and time again, they've been proved to be wrong, so we know that.
Yeah, absolutely. I'm going to bring Neil in just now because he's waiting. Hello, Neil. How are you?
Edith, hi. Hi, Donald. Good. Thanks for having me on.
Evening. Nice to see you.
You've no doubt been listening in the background, Neil. So thoughts, I'm sure you have many, but any particular thoughts in relation to these proposals?
It's well, I agree with Donald's thoughts, absolutely. But there's been a lot of excitement about this, but I don't really feel that when the arguments are properly examined, that there's going to be a political appetite necessarily for juryless trials, because when it comes to deciding which way the members of the Scottish Parliament are going to vote, the civil liberties lobby is quite strong, by that point, there'll be quite a groundswell of understanding of the importance of juries, the important place it has in democracy, and the importance of an accused person being tried by a diverse body of a jury, not by a single white judge in the High Court. So I've got some doubts as to whether it will ever come to pass, although I think some of the other reforms will. And juryless trials will hopefully be a casualty of the sausage factory that is making laws in Scotland. But there's perhaps one matter that I've been reflecting upon that I think is quite important, and it follows from Donald's point about, are the public bright enough and clever enough? Well, I was reading that there are statistics that suggest that perhaps about half of all rape prosecutions result in a conviction. And of course, the complaint is about the half where there are acquittals, but no one complains about the half in which the accused people are convicted. So it's clear to me, therefore, that the public are well able to understand and to sift through the so-called jury myths, again, whatever they are, but to sift through them and to convict those people who should be convicted and to acquit those who should not. And that, to me, is the kind of practical consequence that we already have a functioning working system, and the juries are, in my view, bright enough, clever enough, and have enough common sense to be able to convict where it's necessary.
Absolutely, Neil. And we see that. I mean, as you say, these jury myths, to my mind, are myth. That's a myth in itself. And again, that research was not based upon real jurors. It was based upon mock juries. Certainly in Scotland, there's been other research in England which is far more reliable, where the professor's name escapes me at the moment, but which suggests completely the contrary to these alleged jury myths that we see here. But we see juries across the country, and they range from very young people who you can see engage in very they're up to date in their clothing, and you imagine in social life and all the rest of it. So it's not a bunch of 15 fuddy-duddies that are wheeled in. So again, it's deeply insulting to the general public to be saying these things about them with really no basis. Yeah. And I agree, Neil, doing trials, particularly rape trials, pretty much back to back, it's rare that you would think, goodness, that jury got it completely wrong. You can see why they decide what they do, and I certainly have put my trust in juries, and you can. It's clear why they've come to the decisions that they do.
I noticed, Edith, that in the press today, there's a new report by the Law Commission in England and Wales, which Joshua Rosenberg was highlighting. I don't know if you saw that. So this is about to become a UK-wide issue, because the Law Commission has published a paper in which it's not only suggested that they might remove juries altogether in England and Wales from sexual offences, but also go somewhat further than the proposals in Scotland to include limiting cross-examination on a complainant's personal records, presumably telephone records and that kind of thing, social media records, further limiting questioning on cross-examination on sexual behaviour, restricting questioning on any questions about compensation, and so on and so forth. So, this is about to become a UK-wide issue, and hopefully the publicity generated by that in the media and the telly and such like might help to generate a public concern about the proposals in Scotland.
Absolutely. It seems that always, or usually, the way that we would follow England, but I saw that. I read briefly a report on that today, and I did worry that things are going in the opposite direction. Donald, I don't know if you noticed anything about that today in this proposal from down south.
No, I was busy working. I didn't have time to read the papers today. Of course, we already have severe restrictions on the questioning of complainers in rape cases and other such cases, to the extent that often you're prevented from asking questions which you feel is a matter of common sense. Of course, a jury would want to know. But these rules are applied very, very strictly up here. So there's a great deal of protection has already been afforded under the criminal law, so that any change that is being made in England in that regard is certainly following down the route that we've already set off.
Absolutely, and you're right. And there's no mention of that when there's criticisms about conviction rates and whatever else is being thrown about in a rather uneducated way. And your point from earlier about people who really understands the criminal justice system, what is your understanding about it, what are the rules of law, and that will show what the people that are fundamentally going to make the decisions here actually know about it, and expose them for really being qualified, as we were saying, about whether they're equipped to vote on it or not.
Well, what you said is both valuable and interesting, and that is banner headlines are invariably about acquittals. Nobody launches a banner headline saying an innocent man may have been wrongly convicted. So it's always assumed that a guilty verdict is somehow absolute. But a guilty verdict is no more and no less than the opinion of at least 8 people on a given day. 8 of 15. And the next day, 8 of 15 may come to a different conclusion. I'm like you. Professionally, you will come away from a trial and you don't think it's the right verdict. You don't feel it's the right verdict. But almost invariably, when you sit down calmly and look at it, you can at least understand why a jury has come to that decision. You, as an individual, you may not agree, but then that's democracy. But you can see why 15 people have come to that decision. And the thing that you have to do as a defense lawyer constantly is to say to yourself, 15 of them and only 1 of me, and that's the verdict the jury came to, and that's the system.
Yeah. I wonder if do you think, Edith, Donald, does this not constitute another development of an attack on the right of the accused person to put their case in court? I mean, if you think back a little while, with Section 274, you've got the use of the CGM case to tighten up on relevancy to a degree which is almost unacceptable in some cases. Then a plethora of other 275 cases in which the defence from the accused's position, which would have been undoubtedly allowed to be put 10 years ago, is no longer allowed to be put. We've now got DASA 2008 cases where you can include serious sexual offending that don't require to be individually corroborated. They want to get rid of not proven, then juryless trials. It's an endless conveyor belt, isn't it, of attacks by the legislature and pressure groups on the right of an accused just to tell his story at the trial. And that's very depressing, I find.
Absolutely. And where we are heading, and I think it's already been hinted at by a comment once made by a judge, that you were once entitled to a fair trial. Now you're entitled, or you will be entitled, to a trial, where all sorts of competing interests have to be taken into account. And inevitably, that is going to water down the right of the accused, as Neil says, to go into court and put his position and have the evidence against him tested and challenged in front of a jury. And that is part and parcel of, and I don't know why, but it's part and parcel of the political will to take apart the Scottish legal system for some reason.
Yeah, absolutely. And you're right. And trying to explain these rules to an accused person is a challenge, because they don't understand it, and quite often you find yourself unable to explain it because you don't really understand the reasoning yourself. I think from you know, our chat, we could probably talk about this, and we do talk about it frequently, but we could talk about this for some time, but we are fast running out of time. So can I thank you both very much indeed. Donald, thank you so much for your time, and Neil, thank you for joining us tonight. Really interesting contributions. As you say, Donald, this is what we need to do. We need to keep talking. We need to be educating those who are going to be making decisions, and, you know, keep saying what we're saying, because we are the people that have the information. We are the ones that can assist in this, and we're the ones that are saying this is just not right, not through self-interest, but in the interest of every member of the public out there. So thank you so much again for your time and your contributions. We really appreciate it, and I'll see you both soon.
Thank you.
Take care, both. See you soon.
Bye now.
Our certification courses are the ideal way to increase your knowledge in a specific area, gain recognition, and give your career a lift. With strictly limited numbers, these bespoke courses afford you valuable time with our expert trainers, as well as beneficial peer-to-peer learning and networking opportunities. By broadening your understanding of non-core legal areas, you can expand your services, and a certification from Scotland's professional legal body provides you with demonstrable knowledge, inspiring confidence from your clients. To learn more, please visit the Law Society of Scotland's certification webpage.
So welcome back. We are now moving on to technology, and something that seems to be, as I said at the start, dominating headlines, and something we probably all need to learn a bit more about. So to tell us how we can do that, I am pleased to introduce our next guests, Rachel and Elizabeth from the Law Society of Scotland. And I think Ali is going to pop on as well. Hello, Rachel.
Hello, hi Edith, how are you?
Good, how are you?
Good, thank you. Glad to be back.
Oh, lovely to see you. And Isabel, lovely to meet you too.
Hi Edith, hi Ali, lovely to be here, thank you.
Good stuff. And yeah, Ali's joined us as well. So Ali, I think first of all we're talking about surveys and things, but you have a survey results to share with us to kick us off.
Yes, absolutely. Well, thanks everyone for joining us tonight. Thank you, Rachel and Isabel. Great to see you both. So I have been involved in some recent conferences with the Law Society, talking all about matters in relation to technology. So yesterday we did the Wills Trust and Executive Conference, talking in particular about Chat GPT and AI, and to try to make things interactive, did a bit of live polling, asking people, the lawyer audience, of whom there were about, I think, 92 or 94 or something like that, all about technology-related matters. And suppose the headline results in the survey are in relation to who wants to know more about legal technology and how to innovate as a lawyer. 100% of those who responded to the survey, I should say, which was about 45, 100% said they were either very interested or quite interested. So we've got to take from that that no one is not interested in relation to knowing more about technology. And when they were asked about how important legal technology is going to be to their careers going forward, 98% said critically important or very important. So 2% said not that important. And there is a kind of bit of a lawyer mindset. I want to focus on black letter law. I don't really like technology, and we're going to cover all of that. And we're trying to solve some of that with some of the content and events that we've got and we're going to talk about tonight. So that was the kind of headline stuff from the survey, and it leads us into things that we've got planned over the next couple of months to try to build out tech skills, tech knowledge, have a bit of fun in relation to legal tech.
Yeah, no, I think you're absolutely right, Ali. And I think obviously what the surveys have shown us is that we obviously know that tech is a hot topic, and obviously the surveys have showed us that most lawyers want to learn more about it. But I think what we've found is that although there is this clear desire to learn more about tech, it can quite often be difficult to know where to start, especially now where tech has grown so exponentially in the past even couple of weeks, couple of months. It's always ongoing. So in order to tackle this, we paired up with Hey Legal to create the Legal Tech for All Lawyers Foundation course, which we'll start with. And this online course is split up into easily digestible 15-minute micro lessons, and that is with the aim to equip you on these legal tech basics, which we hope will turn into this stepping stone into your understanding, more comprehensive understanding of legal tech. So the course is hosted by Sam Moore, who is one of Scotland's first accredited legal technologists. And from the beginning, we start with asking the questions that you probably ask yourself. What is legal technology? What impact is this going to have on me? How is it going to change the way that I operate? Before moving on to the more specific questions, such as what is document automation? What are other people doing? Who are the biggest players in the tech field? So I think just to sum up on that, the goal of the course is to provide you with that baseline knowledge that will hopefully spark this interest in exploring and hopefully embracing legal tech more fully. And if you do find that completing this, and I sound like a really bad chat show host when I do this, that hopefully when you complete this and you're feeling quite motivated and have this desire to learn more about legal tech, in June we do have our Law and Technology Conference, which Isabel is just going to touch on a little more, if that's okay.
Yeah, thank you, Rachel. Thanks, Ali and Edith. So yeah, it's great to be here to talk about the Law and Technology Conference. It's going to be happening on the 14th of June at Dynamic Earth in Edinburgh. So you've got the opportunity to attend in person or online. We will aim to give the same experience both online and in person. We ran it last year in that method and it worked really well. So you'll be able to interact whether you're in the room or at your computer. So it's sponsored this year by the Cash Room, Amicus and Mitigo. And also we're running it, as Rachel said, in conjunction with Hey Legal. So it's going to be a great opportunity to network with other like-minded tech lawyers, but also lawyers who want to learn a little bit more about how to use tech in the best way. So we've got a really great array of speakers. We've got Sir Geoffrey Voss, so the Master of the Rolls. He's the opening keynote, and he's he's very, very passionate about how to use, in particular, AI to forward judicial decision making. So he's really excited to be taking part. This will be one of his 2 major speeches this year. So really good to hear his take on technology and what the future holds. We've also got leading legal automation expert Catherine Bamford from BAM Legal. So she's been named by the Financial Times as a top 10 legal technologist. So we're very lucky to have her, as well as Lavinia Osborne, founder of Women in Blockchain, and a number of other very well qualified speakers from heads of technology for firms such as Shepherd and Wedderburn, and legal technologists from De Novo and Mitigo. So there's going to be a number of themes and topics. So I'll just run through a couple that we have. One of the ones I'm most excited for is a situational cybersecurity session, which is going to be run by Mitigo, in which there'll be interactive situations, so you'll know how to react when to ransomware attacks, and just actually in real time get practical examples for how to deal with these problems. We'll also have targeted sessions to in-house smaller firms and also larger firms for how to use tech in the best way for you. We're obviously conscious smaller firms have smaller budgets, so we'll want to work with the tech that they have. that brings me on to another great session we have, which will be looking at just improving basic skills, whether that's through Microsoft Office, Excel, so working with the tech that you have in the best way to get the most from it, whether that's through contract automation and drafting. We also will kind of look more to the future, and we're going to look at the intersectionality of AI and IP, the challenges this brings, as well as a deep dive into fintech and cryptocurrencies regulation. So there's going to be lots of opportunities for different sessions, breakouts, so you can choose which topic you are most interested in. But the beauty of it being recorded and hybrid is you'll be able to get the recordings afterwards and watch the sessions again, watch the sessions that you've not been to on the day. So we look forward to welcoming you there. And I suppose that sort of brings me on to the next thing that I'd like to speak about is the in-house annual conference that we have running on the mornings of the 20th and the 21st of June. So that's all going to be online from 9:30 until 1, and it's sponsored by St James's Place. So this in-house conference is much more tailored towards in-house lawyers, and again, we've got different breakouts where you can look at which area is best suited to you, whether you're interested in public procurement, GDPR. We've got a fantastic session by the Chancery Lane Project, as well as speakers from Edinburgh City Council, Dumfries and Galloway Council, and Martin Nolan, General Counsel at Skyscanner. So we hope in this conference that there'll be a lot of variation, whether that's black letter law or sort of more practical skills, but all centered around in-house lawyers. Then we will also have the Rising Star Award for in-house lawyers. So, that'll be interesting to see for who's coming up next. I think that's probably it. You've heard from me for the last 10 minutes. I'll be quiet now. But yeah, that brings me on to Rachel for the for early careers.
Yeah. So obviously, Isabel there mentioned Rising Stars, which is quite apt for what we're going to speak of next. And what I want to talk about now is just particularly surrounding trainees. So if you're watching this and you are a trainee, or if you're watching this and you have trainees joining your firm, then this will be good for you to know. So at the Law Society, we have teamed up with those at the O-Shaped Lawyer Group. And we have launched our newest trainee CPD module, and that surrounds all about how to be more O. Now, if you were like me and didn't know what being more O meant, this just means kind of what it says on the tin. It's all about creating that well-rounded lawyer who has good knowledge of the law, but also is client-led and people-focused. So committing to this shape of lawyer is absolutely perfect for those who are just at the start of their career and will soon obviously be heading into practice. So we're pledging our commitment to provide trainees with knowledge of this mindset through creating a series of trainee CPD sessions that our delegates can learn about the O-shaped attributes and how they can apply them to benefit their everyday practice. So this is open to all trainees, whether they are on our existing trainee CPD programme or if you'd just like to take this as a one-off. It's open to all trainees. So yeah, any questions about that, just give us a shout at cpd@lawscot.org.uk. And I don't know if we mentioned, but I should just note the Law and Technology Conference is free to all of our members, and that is whether you're attending online, in person, completely free for members. So be sure to take advantage of that if you can.
Well, I can't say I'm surprised, but that is a very comprehensive and excellent outline of all the things that we talked about, because we had a little pre-meet about this, and you've done such a brilliant job in explaining all the things that are coming up over the next little bit. I'm obviously mostly involved in relation to the technology conference. So that was a brilliant outline of everything that's on there. Isabel really made quite a big effort to try to break down the barriers, as you said. We don't want this just to be an event that's for people who see themselves as techie. It's too important now, as the survey showed. Everyone's kind of not waking up, but they're realising that this is something that just has to be known about, to be embraced. And also there's loads of opportunities. It's not just about fear or saying this is something that I have to do. It's actually something you can say, right, I can just get a handle on this and can use it to boost my own productivity. We're all trying to get our time back. We're all trying to make things work easily. And the real key to the recent developments around ChatGPT and such platforms is that they're intuitive to use. Yes, you can learn ways to make them work better, and we cover that in some of the content. We're going to put some more content out onto the Shaping Your Success channel that we saw Donald featuring in earlier. But essentially, it's pretty intuitive. In fact, after his departure, Neil Hay, who was on earlier, sent a message saying, feel free to reference the fact that I asked ChatGPT to write an anniversary message to my wife. And he said that it was so good that she straight away knew it wasn't him that had written it. There's loads to do. We've tried to introduce a social element into the tech conference, so if you can make it along in person, that'd be great. Try to network an event after it as well. Trying to be a bit more tech scene related and just make people relax. I think the dress code is, it's basically be comfortable, just come along and think of it as a day off. Don't think of it as extra work. As we always try to do in Hay Legal, the learning that works best is stuff that doesn't feel like extra work to do. So that all sounds great. So Edith, are you going to sign up?
Obviously, yeah.
I was going to offer you a free place there, but it doesn't really work with the technology conference.
Yeah, it is free. But we're really hopeful. So I think the numbers are currently up around, I think we're heading towards 400 as well, is that right?
About 400. We've got about 70 in person, and it's probably quite important to note that pretty much all of the speakers will be there in person as well. So coming in person will be a great opportunity to speak to some of the speakers afterwards. While you can ask questions when they're, presenting, it's sometimes quite nice to catch them afterwards as well. And it's a fantastic venue to have it in Dynamic Earth. It seems quite apt. So it will be a fantastic day, I hope.
I've never been to Dynamic Earth. I mean, but what is it like? What type of building?
Got a huge iceberg in it, so.
Right.
But I don't
meet you by the iceberg.
Okay. No, as I say, 400 lawyers. I don't see why we can't double that. I mean, what's the downside? You register, it's free. You can watch it whenever you want after it. If you take away one piece of insight or wisdom or different way of thinking, then job done. So, and you get 6 hours CPD, and I tell you, around about October, people will be very happy that they registered for 6 hours of free CPD in relation to the tech conference. So it's all positive. So thank you for that.
It sounds great, and obviously a lot of work has gone into it. So any solicitor not taking up on it would be a bit daft, because it's all there. And as you say, it does sound scary. Even I had some involvement previously in helping Ali, and even tonight listening to you all talking about all these acronyms, you think, good grief. But it's better to be amongst it than on the outside. And what you're explaining there and describing, it sounds like a really user-friendly experience for everyone. And good that there's the in-person element as well. I think we can all get a bit too used to being on here and not meeting up in person, but that's a great aspect to it as well. So it all sounds brilliant. And I think, Ali, you're going to put a link to the event on the video description once we upload it or once it's uploading anyway, but so people can click on that and get access. Thank you so much to everyone for explaining that. Really enthusiastic, and I'm sure you'll have encouraged a few more folk tonight with the various courses. So thank you so much for for coming on, Rachel and Isabel. And thank you to our earlier guests, Donald and Neil, for their great chat, and also Ali's assistance as ever behind the scenes and on screen tonight. So thank you once again. I hope you've all enjoyed the social tonight. We thank our sponsors again, and we hope to see you all soon. Thank you.
Thanks so much.
Thank you.
Bye, everyone.